Next is number 10 on the agenda, House Bill 6981, an act concerning social networking, internet sites, and enforcement of electronic mail phishing and identity theft laws. Is there a motion?
So moved, Mr. Chairman.
Is there a second?
Second.
It's been moved and seconded. Representative Stone.
Thank you, Mr. Chairman. This bill came unanimously from the General Law Committee. It does effectively two things. The first is it provides the Attorney General's office with some investigatory tools to compel or enforce subpoenas or interrogatories in his investigation of electronic mail phishing incidents as well as incidents of identity theft. It also provides, in the last section, for at least the start of an ongoing work relating to social networking websites and trying to arrive at some age verification information from those websites. We've had any one of a number of instances in which minors have been accessing those websites and have been subject to predators and either injured or, I think in a few instances, killed in meeting with these criminal individuals. So we've attempted in that section to at least start the discussion on arriving at an effective way to curtail that, if not stop that kind of activity. This has been looked at not only by the General Law Committee and the AG's office, but also by various participants in that industry, most notably MySpace, as well as some cable providers, internet providers, namely Comcast and others. And they certainly have my commitment, if this should move forward, to continue to work to arrive at a workable product, a product that can be enforced and that will make a difference. I urge my colleagues to pass this out. Thank you, Mr. Chairman.
And if I could just ask you a question, Representative Stone, to sort of confirm a conversation that you and I had. There seems to be general agreement that the definition of social networking site is so broad that it seems to include everything that's a blog, essentially, regardless of the purpose of the blog. I just want to confirm, is that your interpretation as well, and is part of your agreement to continue to work on this to address that concern that has been raised by many bloggers for understandable reasons?
Yeah, and as we discussed, that certainly is one very reasonable interpretation of that particular definition. I have committed to you and others that we need to refine that to really hit the target that we're trying to hit, instead of creating what would be not only unworkable, but what I think would be an improper infringement on free speech rights, et cetera. So you certainly have my commitment to continue that.
Thank you. Is there further discussion? Senator McDonald?
Thank you, Mr. Chairman. Actually, this is the first I've had an opportunity to look at this, but if I could ask a question to Representative Stone. It seems to me that a big chunk of this bill is authorizing the Attorney General to issue subpoenas for the production of information relating to the websites that are in question. And I guess my question is that since it would allow the Attorney General to try to enforce those subpoenas in Superior Court, how would the Attorney General be getting jurisdiction over websites that were hosted out of state?
Representative Stone?
Thank you, Mr. Chairman. Well, certainly through if those websites have sufficient context with the state of Connecticut, I assume that they would be subject to the jurisdiction of the state of Connecticut. I would point out that the two provisions in this bill that refer to the rights to, or the ability to issue and enforce subpoenas and interrogatories relate to the anti-phishing legislation, which we did, I think, last session, and the use of scanning decoders we did, I think, last session. It's not part, at least as I read it, it's not part of the social networking section of the bill, which is Section 3. It may be part of that as we continue to work through that, but it wasn't part of that section. The Attorney General's office has this ability in other areas dealing with interstate commerce and out-of-state companies that do business in the state of Connecticut. Certainly the ability to at least attempt to enforce this particular authority has to rest somewhere. It would rest in Superior Court, and obviously the sufficient notices will, the court would make sure that sufficient notice goes out to the affected parties so that they have an opportunity to be heard on those subpoenas. In most cases, at least as I understand it, that when a subpoena is issued, there would be a motion to quash by the affected company, and so they would be subjecting themselves to the jurisdiction of the state of Connecticut on the motion to quash, and that would be their opportunity to contest it as well. Through you, Mr. Chairman.
Senator McDonald?
Well, okay, I mean, I guess, and I understand that this is going to be worked on more when we, if it moves past this committee. I don't mean to prolong the discussion here, but it seems to me that most of these sites are hosted outside of the state, and just having a website that's available to anybody from within the state is generally considered not to be sufficient contacts for purposes of asserting personal jurisdiction over a web hosting facility. And so I don't know what this actually accomplishes. I don't think it actually would allow the Attorney General to do much. There's nothing that would require a social networking website to register to do business in the state of Connecticut if they're not actually conducting commercial activities within the state. And frankly, it seems to me that it would be more likely that the Attorney General would have sought authority to apply to the United States District Court to enforce a subpoena from Connecticut, not the Superior Court, which would have extraterritorial jurisdiction over the potential hosting facility. I understand the goal of this, but I'm going to vote no against this at this point. But maybe if it does get out of here, we can talk about how we can try to address some of those issues going forward. Thank you, Mr. Chairman.
Just,
Representative Stone?
if I may, just briefly, and I certainly appreciate the senator's comment. And in the testimony from the Attorney General before the General Law Committee, he indicated, and correctly, that other agencies within the state have the power to issue subpoenas and issue interrogatories for purposes of continuing their administrative investigations in areas that also affect or in similar ways in which this bill is trying to accomplish for the Attorney General. The Department of Consumer Protection, for example, which is the agency which has at least administrative charge over the enforcement of these laws, has that authority as well. So while I appreciate the concern, it is enjoyed by these other agencies. It apparently has worked for them, but when they call upon the Attorney General's office to further enforce it, they've been, he's responded with the comment that he doesn't have that authority. So and I'll certainly look at the possibility of amending it to take Superior Court out of it and go to federal court. I don't think there was no objection or no stated objection by the Attorney General's office as to what jurisdiction would maintain the authority to act upon or to enforce the subpoena. So we can certainly work on that. Thank you, Mr. Chairman.
Further discussion? If not, please call the roll.
McDonald? Lawler? Hanley? Fox? Kissel? O'Neill? Adinolfi? Amon? Barry? Berger? By? Capiello? Coleman? Dillon? Fritz?
Yes.
Garagosian?
Yes.
Giggler? Godfrey? Gomes? Gonzalez? Green? Ham?
Yes.
Hamsey? Hovey? Hurlbert?
Yes.
Claridis? Labriola? McCluskey?
Yes.
McMahon? Meyer?
Yes.
Morris? O'Brien?
Pass.
Olson?
Yes.
Powers? Rohrbeck? Rowe?
Yes.
Sarah? Spallone?
Yes.
Staples? Stone?
Yes.
Tong?
Yes.
Walker?
Yes.
Wright?
Yes.
Gomes?
Yes.
O'Brien?